Wasatch Report, shooting straight on everything from prepping to politics.
Good morning, everybody, and welcome to the Wasatch Report. I am Suzanne Sherman. I will be your host for this next upcoming hour here on the Cerberus Radio Network, where we defend freedom and liberty from the flames of tyranny. Today is Friday the 13th, year of our Lord 2018. I have a very special guest joining me today. For those of you expecting the Mark and Suzanne show, Revolutionizing Radio, want to let you know Mark Kreslins is currently in the hospital recuperating from a bit of a scare from a cardiac issue. Our prayers will continue for an uneventful recovery. He is expected home today, and then we hope to get him back with his headsets on and doing the show with us. We've had a tremendous response and we're having a lot of fun. Want to thank him for agreeing to come back and join us, and we look forward to getting him back on. Tom Mullen from the Foundation for Economic Education. He has written a couple articles that they have published. He is going to be joining me. I'm going to bring him on momentarily, but I want to let you know we are going to be announcing the winners for the Liberty Classroom Basic Membership. Tom Woods generously allowed us to give away a basic membership for the winner of whoever came up with the best name for the Supreme Court justices. We have a lot of fun. I know Tom Mullen has some great names, and we'll be getting into those with our discussions today. But Liberty Classroom, where you can defend libertarianism, advocate the free market, and win any political or economic debate with the clueless leftists. And I would say some of the clueless conservatives as well, because they're just as big government as a lot of people on the left. That being said, and without further ado, Tom Mullen, I want to welcome you once again back to the Wasatch Report. How are you today?
Great, Suzanne. Thanks for having me on.
I love having you on here. Tom, tell people how they can follow you really quick.
The best place would be tommullen.net, where all the different places I write, I've usually got links and material there.
If you're not familiar with Tom, he's the author of Where Do Conservatives and Liberals Come From? Also, Whatever Happened to Life, Liberty, and the Pursuit of Happiness? A Return to Common Sense, Rewaking Liberty in the Inhabitants of America. And again, you can follow him at www.tommullen.net. Some great stuff. Last time you were here, we discussed your book, Where Do Conservatives and Liberals Come From? And we see that there is a lot of common misconceptions. They have a lot of common ideas that they share. Today, speaking of sharing, you've written a couple articles about the Supreme Court and the consent of the governed and immigration. I also wrote an article on immigration and its constitutional authority, and that was published by the 10th Amendment Center. But these two pieces that you published today, they really work well together. So that's going to be the focus of our discussion on the time that we have together. The first being, and that is the Supreme Court and how they actually usurp what we call the consent of the governed. And this is something I've been talking about for quite some time. We have surrendered our revolutionary legacy. One of the few things that kids actually hear accurately in their education is this phrase, taxation without representation. And it really goes to people being ruled and taxed by individuals whom they have consented to govern them. Have they agreed to these people? And now this ties over with the Supreme Court, which has really usurped what we have, the consent of the governed. Why don't you introduce this article and talk about this, how it tied into the Declaration of Independence?
Well, I think it's exactly what you said, that first we have this principle that no power will be wielded over us unless we consent to it, and elections really are the vehicle for according to the constitutional system. I'm not necessarily approving of any of this, but according to our constitutional system, the election is where we consent to who wields power. It's not where we consent to what power they get to yield. We only consent to what power they get to yield by what's actually delegated to the government in the Constitution, and that's both at your state level or at the federal level. So if there's anything that's not in that original document or some subsequent amendment, and it's not clear that the power they're exercising has been delegated in one of those two ways, then nobody's ever consented to that power. And I don't think that's I don't think when people hear the word constitutional or unconstitutional, I think, you know, their eyes start to glaze over and it sounds very academic. But what that really means is power you have consented to or your ancestors have, and that you haven't chosen to take away by some subsequent amendment. So when you put it in those terms, you know, did anyone ever consent to them, you know, doing anything with education? Well, no, the word education is nowhere in the Constitution. It's not in any subsequent amendment. It's not something the federal government should have anything to do with. You know, that goes for just about I don't know, 80% of everything they do outside the military, maybe 90%. I never actually, you know, tried to do the math on it, but it's most of what they do outside of the military. The Constitution is completely silent on. So should they. They should be as well.
And I've done many shows telling my listeners that, you know, this was not unforeseeable. We had very, very intelligent prognosticators of the day that foresaw this government very soon, as it did, before the ink was even dry on the parchment, I would say, throwing off the restraints and doing what was rejected outright. When we talk about the principles set forth in the Declaration of Independence, with regards to our topic here today, is the phrase that is ignored, that this government should be deriving their just powers from the consent of the government. But what we see again is this usurpation of their restrictions, and the focus goes to equality. So the terms equality is really what we're focusing on, unfortunately, today, and when they use to expand the government beyond their original powers, because, as you say, consent really refers to what was agreed to. This is why I get so frustrated when everybody talks about the plain text of the Constitution, because it is subject to many misinterpretations. If you don't look at the ratification records, again, that goes to what was agreed to, because you say here what was agreed to was specifically provided for the powers that were granted to the general government. Article 1, you mentioned sections 8, 9, and 10. Article 2, sections 2, 3, and 4. Article 3 and Article 5. Let's focus, before we get to Article 5, on Articles 1, 2, and 3 that you mentioned in the article here.
Well, yeah, certainly, you know, one of the things that it should be a warning sign that something is wrong is if you have to have a bunch of lawyers go in front of a bunch of judges and have this long, dramatic argument about what's actually in those sections, because it's pretty black and white. I mean, if you go to Article 1, Section 8, it lists all the things the federal government is supposed to do, and you know, just in case anyone didn't get how this all works, they passed the 10th Amendment to say if it's not there, then, you know, Congress shouldn't be doing it. And so if you have to have this complicated process to just try and figure out what's in there, you should probably assume that it's not there. And I guess where I'm coming from is, I'm sure that you know, a room full of lawyers and judges can make some complicated argument for why they think there's something there that the average person can't see. But why not just offer an amendment? When you offer an amendment to the Constitution, you find out by the Constitution's standards whether the people consent to this power or not. So why does it never happen? Why, when someone has some new idea about what the federal government should be doing, do they not just offer an amendment? And I think we all know the answer. It's because they know that the people aren't going to consent to this, or don't consent to this new thing they want to do. And I mean, that really goes for all of what the federal government did in the New Deal, and you know, most of what's happened after. I mean, what the federal government's supposed to be doing, they were already doing by probably, you know, 1791, and anything new that they've done after that has all been a problem.
You know, you mentioned, why does it take such a long decision if we have these 9, what do you call them? High robed, what is it? Black robed high priest. Yes. I was looking up Heller because I've started a new show called Case in Point, where I will select certain what we consider landmark decisions. And I'm going to be picking them apart from the effect they have on us and their constitutional authority for the court to have even heard this. And the first one I started out with was Marbury versus Madison. Kevin Gutzman came on the air and discussed that with us. But now I'm going to be looking at Heller, because we hear Antonin Scalia was a true constitutional originalist, and he looked at the plain text. Well, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms, shall not be infringed. Heller, the opinion, I actually ordered it on Amazon because it's 157 pages long. What they should have said is, we have no authority to hear this case in the first place. 157 pages to carve themselves out exceptions and definitions to do something that the people never consented to in the first place. Somebody had asked me once before, would the Constitution be any different absent, say, the Bill of Rights and the 10th Amendment? And I think, going by what you said earlier, the answer clearly is negative. Don't you agree?
Yeah, there were arguments at the time that the Bill of Rights would be a bad thing because it would suggest that there was any power in the Constitution that isn't clearly stated. In other words, if the assumption of the Constitution is that the government can't do anything that's not expressly delegated there, then a Bill of Rights would just confuse the issue, because you'd be now saying something that has already been said, and implying that, let's say, if you've got a Bill of Rights that have a bunch of prohibitions on the government, it would lead to the assumption that things not prohibited might be allowed, and that's the wrong assumption. So the Hamiltons and other people like him were arguing against the Bill of Rights for that. And strictly speaking, I think that's correct, okay? But I'm sure glad it's there, because let's face it, the way that most people think about the Constitution is, it's only limited by what's in that Bill of Rights. But I like to point out the 9th and 10th Amendments are probably my favorite of all of them, even more than the 2nd or the 1st.
I think a common misconception also, and this occurred, it really hit me when I called the helpline for the American Community Survey, which was sent to me from the Census Bureau. Now, as we know, it's constitutional for them to need to know how many people are within a certain area for appropriation of representation in the House of Congress. However, they don't need to know how many toilets I have, how I heat my house, who stayed here for more than 3 days, and the other garbage they wanted for 18 pages. So I called and I asked, what is your constitutional authority? And the woman cites a federal statute. I said, no, a statute is not a constitutional authority. This was not consented to, agreed to in the ratification process. And she said she was completely lost at this point. I said, I'll give you a hint. Look under Article 1, Section 8. And after about 30 seconds of silence, she triumphantly said, oh, it's not there. That means we can do it. Now, this is a government employee who is under the impression that if it's not there, they can't do it. And people fall into this default that we have to work within the constraints of what we have and not talk about solutions taking us beyond there. And that's what we try to do that is so different at this network. For instance, I was having a conversation with a scholar. I'm going to keep his name out of it just in case I'm misquoting any of it. But we were talking about Brett Kavanaugh. What do you think about him? I said, well, I really don't like how he used the Commerce Clause to justify the Affordable Care Act in a written opinion. And so what he said was, what you have to understand is he was on a lower district court and he has to abide by, because I also mentioned that he would uphold Roe. He put it in the context that from a justice on a lower court sitting on that bench, he has to go by what the Supreme Court, the highest authority, the highest court in the land, said on any given subject. So if you take Roe into consideration, he has to uphold that. And I said, that is my problem. It's with the system as it is. Because if you are forced to uphold a law that we know is unconstitutional, he's part of the problem. The solution for me personally would be not to accept that appointment, because you are contributing to this myth that we have to fall into whatever they say. And if they're wrong, so be it. Too bad, so sad. We have to wait till the next ones are appointed to fix the problem. This just does not seem like a Republican form of government that was consented to. Is that a fair statement?
Yeah, well, at least not a constitutional republic, with the system that, you know, they said that they were setting up back then, and wrote, you know, all those Federalist Papers, re-emphasizing the point that hey, the government's only gonna do what's written in here. Here's all you anti-federalists, some great prognosticators themselves. You don't have anything to worry about, because, you know, again, the government's only going to do what's in this document. Everything else is going to be left to the states. You know, and one point, you know, that sometimes gets lost as well, is that as far as the federal government is concerned, the states have unlimited power. I mean, it's up to the people to decide what their own state is going to be able to do as well. And I live in one of the few states that doesn't have a version of the Second Amendment. I should say that the Second Amendment is a version of what's in a lot of the state constitutions, most of them, some kind of clause guaranteeing the right to bear arms. New York doesn't have that. So under the original system, you know, the states could ban guns if they wanted to. And that's, you know, the only reason that laws get struck down for being unconstitutional against the Second Amendment is because of this whole indoctrination clause of the 14th Amendment. You know, the original system was, if your state wants to ban guns, that's up to your state. You know, we just have nothing to say about it here at the federal government.
And that's what people really, the pro-gun people, have a real hard time with that, because they sure liked it when, you know, they do not like when the federal government upholds anti-gun laws, but they sure love it when they strike them down in cases like California. And when I talk about issues like national reciprocity, which is clearly a state issue, they want a one national solution where the general government is forcing this down. I've actually heard them say the term "force it down the throat" of the state governments. The problem is, what happens when things don't go our way? We recently had a Supreme Court ruling on civil asset forfeiture, or one that people really liked, that the state police, local police, must get a warrant before searching a vehicle on private property. Well, what if they had ruled the other way? They can just as easily rule on the side of tyranny. And then where are we if we have said we have to accept this system for what it is here? So you had said that judicial review is really a history of unelected judges lending legitimacy and legal sanction and sanctioning to the federal government, seizing vast new powers without the consent of the governed. What is your rule of thumb for judicial review? You discussed that in your article, and then we'll go over to immigration before we run out of time with you.
Well, you know, Jefferson and others have, strict constructionists have argued that either they have no power to decide what's constitutional or not, or at least I think Jefferson's position was more they have the power to do that, but it's not binding on the other branches. That every branch should be deciding what's constitutional. And of course, we all know that he and Madison eventually took the position that the states also have a say in this, and that they're the ultimate say, that if all three branches fail to come to the right decision and a power is being exercised that is not delegated, that the states can just nullify it. So the idea that they're the last word on whether a power is delegated to the government is something that strict constitutionalists throughout history, right from the beginning, have said is not right, is not true. So, you know, I think maybe judicial review could be useful as an opinion, but you know, it's kind of fuzzy what their power is. I think that's one of the few fuzzy things about the Constitution, because I think there were some people during the ratification process that were talking about the Supreme Court doing exactly what it's doing. So it's not like this is just out of left field. They just discovered it, as they have so many other things like education and pension programs and healthcare.
And when I had Kevin on with me when we were discussing Marbury versus Madison, you know, we did distinguish between judicial review, where the Supreme Court here or the lower federal court cases or cases, district courts would examine legislation and overrule it if it was unconstitutional. And we also had the discussion of a negative veto by the legislator, by Congress, over state laws, which was rejected outright as part of the Virginia plan. But even if judicial review was not rejected, aren't we getting essentially the same thing as the negative, as the veto of the federal government over state laws, particularly over areas which were never delegated to the general government? Aren't we essentially getting the same thing?
Yeah, absolutely. And they're not supposed to be doing that. If it's not a law forbidden to the states by the Constitution, they should have no say in you know, the quote unquote constitutionality of a state law. That's just something that wasn't all of this. The whole constitutional system understood that the federal government would be involved in very limited things, and the rest of them, they just have no power to have any say in them. So, you know, as you mentioned before, and this is the reason I wrote my book, Where Do Conservatives and Liberals Come From, is because, you know, I think people tend to think of conservatives as the great upholders of the Constitution, but then when it comes to things they like, all the arguments come in that you hear from the leftists about, you know, I wrote the immigration article only because immigration is a timely topic. I'm hoping to get the chance to write on a lot more that, you know, the left doesn't, would probably be more interested in yelling at me about. But, you know, when I wrote the immigration article, I started hearing things, well, what do you want to go back to the immigration policies of 1798? Good luck with that. Oh, okay. So what you're saying is, the Constitution is a living document, right? And it needs to change with the times. I think I've heard some democratic socialists saying the same thing, you know? So when it comes to gun laws, I mean, everybody's high-fiving each other when, you know, the Supreme Court strikes down a law in Chicago or Nebraska somewhere that they say is unconstitutional under the Second Amendment. Well, the Second Amendment doesn't say that. It says the federal government is not going to infringe the right to bear arms. Now, personally, I have no dog in this race. I'd get rid of it all. I'm a hardcore libertarian. I'd get rid of the states. I'd get rid of the cities, everything, and go to a private law system. But according to its own rules, you know, neither one of these major factions, political factions, seem to want to follow them when it's inconvenient for their policy preferences.
Yeah, absolutely. And that's what I tell conservatives. You are just as guilty as the people that forced Obamacare on us, like you said earlier, going back earlier, Social Security, because they have the power. They say, now that we'll have the Supreme Court on our side, this is the time to have national reciprocity. Again, once the government starts adopting standards for the issuance of these permits now, even though they say that's not part of it, we know they're going to have mission creep. We're not going to like it. We're going to get laws that are restrictive, such as California, New York, and not going to have laws such as like what we have in Utah, Wyoming, Arizona, Alaska, Montana, and so on. So be very careful what you hope for. And I still have people, I'm going to talk about this on another show, gun owners of America are using a misinterpretation of full faith and credit. You know, the plain text argument is what got us, for instance, the incorporation doctrine, where it says no state shall. They don't get past that. They don't get past that, and they don't understand the system of federalism. Going to immigration, who actually had the authority? When I tell people that the general government has absolutely no authority to regulate immigration, they get apoplectic. They think that I'm saying we are just going to open our borders to invasion. They don't understand federalism at all. I think our two articles are very good companion ones. The one I wrote, The Constitutional Solution to Immigration, and yours as well. Again, at the Foundation for Economic Education, you have here your article entitled, Does the Federal Government Have the Power to Regulate Immigration? And you you get into what Thomas Jefferson and James Madison would have said. I'll let you run with that one for a minute and talk about your article.
Well, yeah, basically this came up with the Alien and Sedition Acts in the late 1790s. And, most people, I think, remember the Sedition Acts because it was just the more onerous sounding, because they were regulating speech and putting people in jail just for criticizing the government, literally. But what they also objected to, the Alien Acts, the first act referred to, allowed the government to deport people. And, Jefferson and Madison both wrote opinions, or wrote, I should say, resolutions that said the federal government, we're objecting to this because the federal government does not have this power. It's a state power. And if they were right, now let's not forget, James Madison is the guy who wrote the words of the Constitution. He didn't write the Constitution in terms of, it wasn't all his idea. In fact, a lot of it wasn't his idea. But he's the guy who actually drafted up the words, and he said that power's not there. So if he didn't think he wrote it in there, then I don't know where they think it came from. Some people will come back and say that the Article 9 paragraph that says they can't regulate migration until after 1808 is a de facto grant of power. And I would admit it's a rather troublesome paragraph, but it's one that Jefferson alluded directly to, and he said, well, they just put that in there out of abundant caution. He didn't say that they granted power after 1808, and that's really a backwards reading. Because they've forbidden something in one place does not mean that anything else is delegated. That's backwards. That's how you govern individuals. If there's a law against roller skating on Wednesday, then you can assume an individual can roller skate on any other day of the week. But the federal government doesn't have this right to liberty that individuals have. So, again, Madison is the guy who wrote the paragraph about the migration and importation, and we all know that this was mostly about the slave trade. And he said that the power is nowhere delegated. Period. Nowhere delegated. James Madison. He didn't say until 1809. He said nowhere delegated. And I think one of the things that about this article, because I get a lot of hate mail about it and snarky comments, if you read the whole thing all the way to the last word, I don't necessarily say the federal government shouldn't be doing this. It's just that it hasn't been delegated this power. And if you look at the foundational case for why they started doing it, I mean, really all the arguments were this is why the federal government should be regulating immigration. Some of them are pretty good arguments. Okay, we'll offer an amendment and let's see what the people consent to, because maybe the people will consent to this, but there will be some limitations or qualifications, or maybe there won't be. But, if you don't do the process, you've really never obtained consent of the governed by your own rules. And I think one of the other points is, with the reason that things are getting so violent and so tense is that the government has gotten into so much that it was never intended to get into, that now everybody's got a stake in everything with the federal government. Who's going to be the next judge? Who's going to win the presidential election? Who's going to get Congress? This shouldn't be that big a deal to the average American. It should be something that they don't care that much about, because the federal government isn't that big a part of their lives. But when it's right down to governing how everything you can say and how you order your own little business in your state, well then, of course, everybody is going to be overly concerned with who wins elections, who gets appointed to this court.
And we're seeing that right now. I'm going to back up for a moment and get into what you mentioned earlier, Article 1, Section 9. This is why it is so important for people to dig a little bit deeper and look at the context. There are some great books out there. We don't have these. We've got historians that have done the heavy lifting for us. You can read Tom's articles. You can go to Brian McClanahan. He has a book, The Founding Fathers Guide to the Constitution. These people have read the ratification records, A Politically Incorrect Guide to the Constitution by Kevin Gutzman, Who Killed the Constitution, Kevin Gutzman, Tom Woods. These guys have done the work for us. There is no reason to be ignorant on these matters with all the information that is available right now. Being as ignorant as we're seeing is truly an amazing accomplishment. So look at the context of these issues. And as you said, here's another ridiculous argument that I hear with regards to Article 1, Section 8, Clause 4. That's the power that was delegated for uniform rule of naturalization. And as you explain in the article, and as I explained in mine, naturalization and immigration are not the same thing. Naturalization is a uniform path to a United States citizenship. It is not the same as determining local social policy issues as to who will remain within the sovereign and independent states that came together and formed this union. And you'll like this one, Tom, because here's the argument that people give me to get around that bit of history. Well, you have to immigrate before you can be naturalized. So therefore, we're just going to imply and hand over power. But don't you think that with all the discussion, all the debates, the founders didn't understand that concept?
Well, yeah, of course they did. And again, you know, I think you point out some good writers there and scholars. One of the things Gutzman especially always emphasizes is, you know, if you want to find out what exactly they meant by something, go to those ratifying conventions. There's some records of those, and you can find out exactly what the people who voted for the Constitution were told, and they were told pretty much the positions that we've taken on this program today. They were told, hey, don't worry, it's not going to do it. Any of these other things you're worried about, it's not in the Constitution, only what's expressly delegated. And I encourage people to read the source documents. Go read the Kentucky and Virginia resolutions and get Madison's own words for yourself. Get Jefferson's own words for yourself. Again, if Madison wrote the naturalization clause, he wrote the 1808 clause, and he still said the power wasn't there. What more can you possibly want for proof? And, you know, to this wild theory that, well, first you have to immigrate before you can naturalize. Okay, well, I mean, I live in the Canadian border. When I was a kid, my parents used to take us to the Chinese restaurant about every other week over in Fort Erie, Canada. I guess I'm 99% a Canadian citizen from eating Chinese food in Fort Erie at this point, according to that theory. It's just an absurd theory. I mean, I've gone on business to many countries that I'm never going to be a citizen of. People every day come into the United States who are never intending to be a citizen, don't want to be a citizen. It has nothing to do with naturalization.
I have a question from our listener, Andrew. He wanted to know, is the best resource for ratification or for understanding the Constitution, the ratification convention notes? I think you answered that in the affirmative.
Yeah, I think so. And, you know, some of those writers that you mentioned have written some good stuff about it and have gone through Gutzman's book, James Madison and the Making of America. It really was a startling thing about Madison himself. And Madison was a big government guy. He was more of a Hamiltonian. And he was the one that kept suggesting the negative on states' rights, the federal veto, and he brought it up and they would shoot it down, and he'd bring it up again and they'd shoot it down again. And I can't remember how many times he tried to get it in. And you know, the big difference between Madison and Hamilton was Madison walked away and said, well, I gave it a shot, and they didn't agree to the government I wanted, so I'm just going to go with what they did agree with, where Hamilton surreptitiously tried to get his system in regardless of what the people consented to.
Yes, and there's a great book on that as well, by the way, How Alexander Hamilton Screwed Up America, also by Brian McClanahan, and there's a new lecture series on that. I know I'm running over time a little bit with you. I just want to touch on, when did the Supreme Court first start regulating immigration, or when did the federal government first start regulating it? And you mentioned a Supreme Court, surprisingly, which is why these two topics just tie in together so well. You mentioned, I think it was Chui Lung versus Freeman.
Right. This was in, you know, if you go read the opinion, just read it. It's not tremendously technical. It's written in plain English.
And there's a link to that text, by the way, in the article.
Right. And The whole case was over the activities of the California state immigration officer. So there you have it. I mean, the state was regulating immigration at the time, and the federal court struck it down. And it's funny because their language is just, they say, well, these powers must belong to the federal government. What do you mean must? And what they really mean is should. And that's a fine to take that position. But the problem is they haven't been delegated to it. So, you know, the correct, proper thing there was, if people believed what the Supreme Court said, which was pretty compelling, it's hey, if California does something to so anger the Chinese government that we all get in a war, you know, this is going to get all the other states in a war over what California is doing over immigration. You know, if you're going to have this constitutional system, that's a pretty good argument for why the federal government is a better place for that power to reside. Okay, so go ahead and let's try and give it to them. Let's use the process, propose an amendment, make those arguments, and most likely people would have ratified it, or at least some version of it. But or at least they would today.
What they're worried about is the limitations they might get if it goes through the process that is mandated by the Constitution in Article 5. Because, you know, look at the language that they use also in Freeman. The states can regulate immigration only when it's absolutely necessary. That means absolutely nothing. And I was thinking of there's a Migratory Birds Act where the court just said, Congress and the court agreed that there are sometimes the states are simply incapable of managing certain areas. And I think clearly the founders knew that there were migratory birds when the Constitution was ratified. This is, you know, you can't even have that AR-15 or computers or any argument there. What we're seeing, as you mentioned, Madison kind of shrugged his shoulders and said, okay, I tried, but what we did was create a general government that is federal in nature. A system is federal, not national in nature. But Alexander Hamilton was in the back wringing his hands, waiting for this to get ratified so they could put the little monsters in this Trojan horse and set them loose on an unsuspecting republic. And I keep saying, had the communications been what they are today, the agrarians, the Jeffersonians that were subject to the whims now of the lawyers, the financiers, and the mercantilists in the northeastern territories, states, areas, we would have had, I think, a mass exodus very, very early on before it became too late, as the Confederate States of America realized. Tom Mullen, thank you so much for joining me today. You can find Tom Mullen, tommullen.net. Check out his articles. Can people help you donate to Fee at all? What can we do to get people to follow you guys?
Well, Fee.org is the Foundation for Economic Education, where I contribute quite a few articles. So definitely a wonderful libertarian site. And they do have a donate button if you want to contribute. And I encourage everybody to read all the articles there. There's quite a few. This is the organization, by the way, that Ron Paul used to rely on for when he was young, and there was no internet, and there was practically nobody making the case for individual liberty and constitutional government. It was Leonard Read's Foundation for Economic Education, so it's got a very long, prestigious history.
Well, I want to thank you for joining us. We're going to take a break and reset the table here. I'm going to follow up a little bit with our thoughts on these two topics, and then we will be announcing the winner of the Supreme Court nickname, and they will be receiving a free basic membership to Liberty Classroom. Tom Mullen, thank you for joining us. We'll be right back here on the Cerberus Radio Network, where we defend freedom and liberty from the flames of tyranny. Be right back.
Walked out of the grocery store just the other day. She saw my flag waving in the wind, said, throw that trash away. I said, ma'am, I am a Christian man, and I bleed American pride. That flag's gonna stay right where it is, and here's my reason why.
Prepare to attack. Prepare to attack on the count of 3. 1, 2, late. What happened? Where are they? I don't know, sir. They must have hyperjets on that thing. And what do we got on this thing? A Cuisinart? No, sir. We'll find them, catch them. Yes, sir. Prepare ship for light speed. No. Light speed is too slow. Light speed too slow? Yes, we're gonna have to go right to ludicrous speed. Ludicrous speed? Sir, we've never gone that fast before. I don't know if the ship can take us. What's the matter, Colonel Sanders? Chicken? Prepare ship! Prepare ship for ludicrous speed. Fasten all seatbelts. Seal all entrances and exits. Close all shops in the mall. Cancel the 3-ring circus. Secure all animals in the zoo. Give me that, you petty excuse for an officer. Now hear this. Ludicrous speed! Sir, had you better buckle up? Now buckle this! Ludicrous speed! Go! What the hell was that? Spaceball 1. They've gone to plaid!
Are you as tired as we are of government going at ludicrous speed? Listen to Cerberus Radio Network as we bring you Founders' solutions to the flames of tyranny. Cerberus Radio Network, protecting liberty and freedom from the flames of tyranny.
All right, everybody, welcome back here to the Cerberus Radio Network, where we defend freedom and liberty from the flames of tyranny. You are listening to the Wasatch Report. I am Suzanne Sherman. Tom Mullen, who is a very prolific author and was on in the last segment, and we discussed 2 of his articles from the Foundation for Economic Freedom. One was about the Supreme Court. The other was about the constitutional authority for the federal government to regulate immigration. What we were discussing, I should say, was, look, there is a great argument to be put forth that the general government should be regulating immigration. We have become one continental landmass blob, the United States of America. Therefore, it is incumbent upon them to defend our territorial borders. However, what we're ignoring here is the historical fact that 13 sovereign and independent states joined together to form a common, a voluntary union, a compact, and they did not surrender their sovereignty on this matter. The authority to regulate immigration simply was not there. James Madison understood it. Thomas Jefferson understood it. The states understood it at the time. We have the 10th Amendment to reaffirm that assertion. So what we have to understand is, whose responsibility is it? Well, if it is going to be the responsibility of the general government, the founders set forth and the ratifiers set forth a means by which we can amend the Constitution, and that is Article 5. What we're seeing, though, is a hesitation to do so because oftentimes the general population is not going to be in favor of whatever they're proposing. And we're seeing that with regards to immigration issues, with regards to healthcare, with regards to many of these other areas that they are legislating, and they have no authority to do so. When we are taught in school the 3 branches of government that were going to regulate themselves, we have the general government being the legislative, the executive, and the judicial branch, that those 3 were supposed to operate upon each other with a system of checks and balance to prevent this new government from getting out of control, which obviously they have failed miserably in their attempt to do so. But we are not taught that the ultimate arbiter of the powers delegated to the general government and the powers it has are the states themselves. It is not the black-robed high priests or the high priests in their black robes, the judicial temple monkeys, and we're going to announce our award for another name for them in a few moments. I was on a talk show, on an afternoon show out here in Utah, and the host had told me, look, We need the Supreme Court to tell us what the law of the land is. Otherwise, we are going to have fighting in the streets. And as Tom alluded to in his article, and I've said many times before, we have that now for the very reason you are saying we need the Supreme Court. They are causing the fighting in the streets. When it comes down to 5 out of 320 million plus people, to determine who's going to get married, to determine school busing, to determine the fate of the unborn, to determine all these difficult social issues that the founders, the ratifiers, consented to, allowing the states to determine within their sovereign borders. Every single social issue, cultural issue, becomes a point of national contention. We are seeing the violence emanating from that on a daily basis. Jeff, you just saw that 16-year-old kid, this big goon, pulled his hat off, stole it from him, and dumped his drink on this kid. People are being subjected to violence for the kind of hats they wear. We're seeing videos where people are taking hats off people's heads. Look what happened at the presidential during the election cycles at Donald Trump's rallies. There was violence, Antifas going after everybody. Tell me we don't have fighting in the streets. How can we resolve this? By representative government, getting representative government at a local level. What does Brian McClanahan say? Think locally, act locally. Jeff, I've been going on here for a while. Did you want to have anything to say?
Oh, yeah. I unmuted my mic a little bit ago because you had me wound up when you said the law of the land. Oh, my gosh, dude. I hate that statement. Number one, we got to get this whole Constitution in context. It is not law. It is a contract between the states setting up an agent. It is a blueprint for government. It is not laws that regulate the people. You know what, Suzanne? It drives me absolutely insane when I hear that whole, well, the court spoke, so now it's the law of the land. Excuse me? Like, I say to them, okay, go to Article 3 and show me the enforcement mechanism. Show me where it is that they were given power to force you to obey their opinion. Oh, I'm sorry. Okay, rant's done. You can
this is the issue that we come up with. You know, this is how Tom also wound up his last article, that federal involvement in immigration, healthcare, education, retirement pensions, food safety, employment contracts, all of these powers that are exercised by the federal government, they have no basis in the plain words of the Constitution. Plain words here. This is a very simple concept. What we have done now is we have allowed these unelected lawyers, politically connected lawyers, to determine what the plain words don't mean, as opposed to what they do mean. And they err on the side of government power. Every one of these powers should be subjected to the amendment process. If you recall the article I wrote called Parchment and Plants, what we can learn about the Prohibition era and alcohol with regards to regulating marijuana. Again, the general government, I'm not saying that alcohol should have been prohibited, restricted at all by the general government, but they recognized the fact that they did not have that authority to do so. So they had an amendment to the Constitution, and we call that Prohibition era. They regulated alcohol, they prohibited it, they did it the way the Constitution required. And because it turned out to be such a disaster, and we're still paying for the mistakes they made then, I'll get into that momentarily, they amended the Constitution again to repeal that amendment. So if we're going to regulate marijuana, the government has been doing so via the Controlled Substances Act, but there is no constitutional authority for that either. And the Commerce Clause is not a justification for it.
Susan, can I just jump in right there?
Yeah.
Because you just mentioned in the last few minutes 2 clauses, the full faith and credit and the Commerce Clause. Those two, people keep, I had the same thing. I had a guy bring that up the other day concerning gun. He was all in favor of national reciprocity, full faith and credit. Commerce Clause. You brought both clauses up in that whole thing. And I said, okay, here, listen to me. If you are correct, then why didn't, according to, like, it's right in Tom's article, and I'll read the paragraph again, that raises the question, why did the framers bother with sections 8, 9, 10 in Article 1, sections 2, 3, 4 in Article 2, or sections 2, 3 in Article 3? Why did they include Article 5 at all? Okay, so I asked the guy, so why did they put all these limits on power if these full faith and credit in Commerce Clause trump everything and mean the federal government can do whatever they want? It gives them every unlimited power, makes them the sovereign. The states are subordinate then to the national government. Why did they even put those other limiting factors in if your right in full faith and credit and commerce apply? Well, they don't, because they are limited by those ones I just read. Go ahead. I'm sorry, I interrupted.
What people don't understand is full faith and credit was very limited in its scope to apply to judicial proceedings and property records. And it was never intended to render superfluous or irrelevant state licensing powers. And I tell people who refer to full faith and credit, well, I guess I can practice law in any state, even though I only sat for the California bar exam. Or if you have your medical licensing, you can take that to any state. Nobody wants to challenge those issues. And they say, well, that's not a right granted by the Second Amendment. Well, back up the truck. The Second Amendment didn't grant you any rights. It's just a reassertion, a reaffirmation that the power to regulate firearms was simply not granted under Article 1, Section 8. So we have this hodgepodge of let's make it up as we go, depending on whatever the political whim is. So everybody is looking to president, whichever the president was going to be in this last election cycle. It was life or death for so many people, actually, literally, because everybody was counting on Trump to nominate a justice that would overturn Roe versus Wade, or Donald Trump is going to be appointing Supreme Court justices, and they will determine all. That guy Charles Heller from Arizona, when I debated him. Well, don't worry. The Supreme Court will work out the final details of national reciprocity, and your concerns will be addressed then. I said, so essentially what you're doing is turning the Supreme Court into the legislative branch. So much for a representative form of government. So the conservatives are just as misguided, and I will say greedy, when it is in their hands as the Democrat Party, as the progressives. They're all progressives that are looking towards the court to do this for them. The power wasn't there. And what we are seeing is literally fighting in the streets. And this is what Tom had said in this article. The idea of a second American Civil War used to be unthinkable. But think of the violence that we are seeing right now. I submit to you, if we were geographically separated, as opposed to living all amongst each other with these different ideas, I think the fighting would have already come out in a more organized form than what we are seeing right now at this point. That being said, let's turn to the winner of our contest here for a free basic membership to Liberty Classroom. We had some outstanding suggestions, and unfortunately, some of the winning ones aren't really family friendly. So we're going to go with the cartoons. I really like that one. I want to congratulate John from one of our listeners, John Karuna. I think we can give his last name. I want you to contact me, send me an email with your information, how Tom Woods can give you this free membership. So we want to thank you for doing that. That was a lot of fun having that contest, and we really appreciate our listeners participating in that. We had some really great ones. Maybe we'll put out a list to show what they are today. Jeff, I don't know if you saw this. There was an article out here. It came out just July 5th. It was from the Abbeville Institute, the Abbeville blog. This was by Boyd Cathy, and that came out on July 5th. Leftist crazies don't want you to exist. We have a few minutes. Just want to share some of the sentiments that were in here. This individual was in North Carolina, and it was in a parking lot, and there was, I guess he had on his license plate a Confederate or the battle flag, and the license plate was a state-issued license plate. He was a member of the North Carolina Sons of Confederate Veterans. And a woman that was present in the area called him out and asked what that meant. Again, he said it was state issued. It was about Sons of Confederate Veterans, which is about heritage and history, not hatred. And this woman, who claimed to be a Christian, went off with all these F-bombs, racist, fascist symbols, and she just, where is our civility? And then she said, reading this article, you must be a Trump supporter. And again, the epithets, Trump supporters are effing racists, neo-Confederates are racists. Where did we ever think that it's okay to start screaming at somebody in the streets because of an image on their license plate? Where did we get to the point where it's okay to assault a teenage boy, take his hat from him? And these people, there was another video I saw of this woman on a college campus. Somebody was in a coffee shop with a Make America Great hat, and she literally took it off his head, and the campus security comes, and I had to turn the video off. This went on for about 20 minutes, where they're pleading with her, negotiating, trying to get her to give this gentleman his hat back. I submit to you, if you go up and you grab somebody's purse and you're standing there in a coffee shop, the police are not going to beg you to give them, cajole you to give that person their property back. That's armed robbery, or that's robbery. If you have a weapon, that's armed robbery. So what you really need, she should have been arrested on the spot, but we have this tolerance for these people that are creating the most amount of violence here. And again, this is a result of a disease called nationalism. If you want to regulate immigration, the proper authority belongs with the states according to the Constitution as ratified. I'm not saying that's a workable solution given what we have today. Fine, fair enough. Let's have the national discussion. Let's take this from the states to Congress. Congress can propose it. The states can propose it according to Article 5, and then the states will ratify it and delegate specifically to the general government, the national government, pardon my French, the authority to regulate immigration. Because people are saying this isn't immigration, this is an invasion. Well, our government has decided that these aren't invaders, they're friendlies. We are not at war with Mexico. So go to either Congress or the states to propose it, have the states by 3/4 ratify the Constitution. That's the way to do it. If the general government is going to regulate marijuana, that's the way to do it. I'm not saying they should be regulating marijuana. I'm not saying they shouldn't be regulating immigration, but we have a process. I'm criticized because I say we should toss out the Constitution. We should start over. Until that time happens, we need to understand how we have made these mistakes, how we have gotten to where we are now. That's why I'm also starting that showcase and point where I take certain cases that are really impacting our lives, and we can see where we went off the rails and surrendered our revolutionary legacy. We can get it back. And if we can't do it in the current format, we can certainly learn from our mistakes. So if we ever have to rebuild, if there's a major collapse, a major transformation in our society, which means that we have to have a restart, this is again why I combine preparedness and self-reliance with politics. There's going to be some painful times. Those of us that are prepared, those of us that understand what the rule of law was intended for these United States, not the United States of America, we can survive the troubling times, learn from our mistakes, and have a truly representative form of government that recognizes individual liberty. That being said, I want to thank everybody for today. Jeff, thank you for producing. I wish Mark Kreslins a quick and speedy recovery so we can get him back. And congratulations, newest Liberty Classroom member, John Karuna. Everybody, this has been the Wasatch Report here on the Cerberus Radio Network, defending liberty and freedom from the flames of tyranny.